So this is the sentence. The court has considered the mitigation on behalf of the accused person. It has been submitted that the accused person is remorseful and regrets the act. The accused person asked the court to consider that he is a first offender and that he would be willing to assist to bring other perpetrators into book. The defense counsel asked the court to rely on the findings and recommendations of the probation officer, which I have, the report which I have perused. The report generally shows that the accused was of good character until commission of this offense. His family watches for him and asked for a fair sentence so that the accused could go back home and take care of his children and elderly parents. In the pre-sentence report, the ATPU asked the court to consider the impact terror acts cause to the nation, which include loss of life, close of businesses, and generally negative impact to the economy due to sometimes relocation of businesses due to terror threats. The prosecutor asked the court to consider the nature of the case, stating that terror cases are not like ordinary cases. He submitted that had the act taken place, the effect would have been devastating. He also asked the court to consider that a bounty had been placed on the co-conspirator, one Mohamed Yare, by the US government, and this should be an indicator of the threat that is posed by terrorism. The prosecutor asked the court to meet a maximum penalty under the Prevention of Terrorism Act, while the accused person urged the court to give an uncustodial sentence for accused to be under supervision of a probation officer. The judiciary sentencing policy guidelines lists the objectives of sentencing as retribution, deterrence, rehabilitation, restorative justice, community protection, and denunciation. I have considered the above principles and the mitigation by the accused person and the sentiments of the state. Terrorism is a heinous offense which, in my view, calls for a stiff deterrent sentence. In this case, the choice of target, that is KICC, in my view, is an aggravating factor. The Kenyatta International Convention Center is an icon and landmark for Kenya. It is a leading facility in meetings industry in this region. It is the home of many offices, both private and government offices, and houses some legislators. According to the pre-sentence report, it can accommodate up to 10,000 guests in a conference at a time. In addition, it is a tourism attraction site, and had this act happened, the impact would have been cataclysmic. Taking all these factors into account, and also taking into account the period that the accused person has been in custody, I will sentence the accused as follows. In count 1, the accused will serve a sentence of 10 years imprisonment, while in count 2, the accused person will serve a sentence of 20 years imprisonment. So these terms will run concurrently. So of course, there is a right of appeal within 14 days.
certified copy, Your Honor, now of the full judgment together with the sentencing, Your Honor, we appreciate.
Your Honor, I have instructions from Mr. Chacha, who I'm holding brief, that he would also want to have a certified full proceedings. The judgment and the sentence. For him to prefer an appeal. And this matter being a serious matter of public interest. Mr. Chacha pleads that a specific order in terms of the typing and availability of those proceedings be issued by the board, so that the convict does not stay in prison for the term sentenced before he appeals. Your Honor, Mr. Chacha requests that the court can make a specific order within 7 days as a matter of priority.
Okay, I may not be able to exactly say 7 days.
No, I know the work that our registry sometimes has, but what we can say, we can make an order that priority be given. But I don't think to be specific 7 days would help us. So I'll just make an order that priority be given. Yes.
Thank you.
So thank you. I think that's all. So we have Nicholas Kasongoi. Nicholas Kasongoi.